Liability of network service providers under the Information Technology Act 2000. 1. Chapter 12, Section 79 of the Information Technology Act 2000, Act number 21 of 2000, hereinafter for short, the Act specifically refers to network service providers or NSPs. NSPs may be Internet Service Providers, that is ISPs. Section 79 of the Information Technology Act 2000 exempts network service providers from liability in certain cases. For removal of doubts, it is declared that no person providing any service as a network service provider shall be liable under the Act, rules or regulations made thereunder for any third-party information or data made available by him if he proves that the offence or contravention was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence or contravention. Clause A to the explanation of Section 79 defines network service provider as an intermediary. The term intermediary is defined in subclause W of Clause 1 of Section 2 of the Act with reference to any particular electronic message as any person who on behalf of another person receives, stores or transmits that message or provides any service with respect to that message. This definition of the term intermediary is specifically excluded from the definitions of the terms originator and addressee, which are separately defined in the Act. The term originator is defined in Section 2(1)(a) of the Act as a person who generates, stores, sends or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person, but does not include an intermediary in Section 2(1)(b) of the Act. The term addressee is defined as a person who is intended by the originator to receive the electronic record, but does not include an intermediary. Clause B to the explanation of Section 79 of the Act defines third-party information as any information dealt with by a network service provider in his capacity as an intermediary. 2. In the light of the above definitions, it is clear that an originator generates, stores, sends or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted through NSPs to any other person. An addressee may also store the electronic record so received by him through NSPs. An addressee may or may not thereafter retransmit the same electronic record so received by him from the originator of the record through NSPs to any other person of his choice. NSPs will firstly receive the electronic records, messages, information or data meant for the addressee, store the same with their servers and will thereafter transmit the same to the ultimate subscribers who requisitioned for the electronic records, messages, information or data. Though the actions of originator, addressee, subscriber and intermediary overlap with the actions of each other in the technological point of view, law has made an attempt to distinguish meanings of these terms of originator, addressee from the definition of the term intermediary and has specifically excluded them from liability under the Act. Further, all network service providers are intermediaries, but all intermediaries are such as content providers, blogs, distributors, publishers, internet service providers, subscribers, etc. are not network service providers. 3. A number of intermediaries is involved in various stages of the transmission of an electronic message. As an illustration, various organizations such as 1. Internet service provider, 2. Email service provider, 3. Server host company and National Internet Gateway provide some services or other that are used for creation, transmission, storage, etc. of an electronic record or message. At some point of time or other, the NSPs provide a link in the chain through which the message finally reaches the intended recipient and he is able to view it. Internet is a large network that comprises of millions of computers accessing resources and receiving messages from all over the world. There is no one owner of the internet, but many people provide services on which the internet traffic travels. It is therefore difficult to fashion liability for transmitting, publishing any obscene, lascivious material or copyrighted material over the internet on all persons who were involved in transmitting, publishing the prohibited or illegal material viewable over the internet or World Wide Web. Section 79 of the IT Act therefore provides protection to NSPs who may include server hosts, internet service providers, email service providers, etc., who are accessing information provided and published by third parties over the internet. 4. However, if NSPs themselves cause to transmit or publish lascivious material or copyrighted material, then they can be held liable under Section 67 of the Act, apart from owners of websites and web servers for publishing or transmission of the offending material or third-party information. 5. Finding the liability of putting illegal material over the World Wide Web www finally rests with the person with whom the ownership of the material lies and who is directly responsible for having published or transmitted over the internet. The Parliament has absolved from liability all NSPs whose services are used to publish, access any information over the internet, provided that they prove that offense or contravention was committed without their knowledge, or that they had exercised all due diligence to prevent the commission of such offense or contravention. 6. Classification of NSPs under the Act. Under the Act, no classification of NSPs has been attempted. The expression network service providers used in section 79 subsumes within it all kinds of internet service providers, irrespective of what function they perform in the long chain of intermediaries that transport internet content to the desired destinations. The ISPs perform different functions in the task of transporting content, and their liability cannot be uniform. It has to be based precisely on what function they perform. It is therefore necessary to categorize the NSPs into functional categories, otherwise, different NSPs could be held liable under the Act for something which they never played no role in, or for the contents over which they have little control. To give a meaningful disposition of the limitation of liability of NSPs for which section 79 has been drafted, it becomes essential to categorize the NSPs. 7. Filtering NSP liability through the IT Act. The title of section 79 of the Act, Network Service Providers not to be liable in certain cases, makes apparent the object behind the section, which is to limit the liability of NSPs. The liability of NSPs could arise in a number of ways under different statutes. The liability could be criminal or civil in nature, depending on various factors. It is impractical to define the liability of NSPs, which could arise in various forms at one place. Equally impractical could be to amend all our laws which could hold NSPs liable in order to limit their liability. The latter has not been attempted in any of the Indian legislations, including the Copyright Act 1957 till now. The Act does not attempt the former, but just seeks to create a filtering mechanism for determining the liability of NSPs. The idea is that the liability of an NSP for their action or omission be first determined in accordance with the statute under which it arises, and then, if at all the NSPs are held liable, their liability again be filtered through section 79 of the Act. For example, if an NSP is accused of illegally distributing pirated copies of music, then his liability be first determined under section 51A2 and section 63 of the Copyright Act 1957. If the NSP is found liable, then his liability again be tested on the touchstone of section 79 of the Act. 8. In this context, the expression under the Act, which has been used in section 79, has created some confusion. Apparently, this limitation of liability would be applicable only when the liability has arisen under the Act alone. This could not be the motive behind drafting Section 79, especially when the Act does not attempt to define the liability of NSPs in any of its provisions. It only talks about limiting their liability. For the removal of doubts, it is desirable that the expression under this Act be removed from Section 79 to resolve the dilemma of NSP liability for subscriber infringements. While relatively few cases addressed the issue, the same did often reach different conclusions. Liability of NSP under the Indian Copyright Act 1957. 1. The Copyright Act 1957 was obviously drafted in complete oblivion of the phenomenon called Internet. Even after its amendments in 1994 and 1999, it does not contain any express provision for determining or limiting NSP liability. However, some provisions in the Copyright Act could be interpreted to have some bearing on the liability of NSPs as per Section 51A2 of the Copyright